Hello everybody, Nation Still Jackson CPA here with another important update for you regarding the Paycheck Protection Program loan forgiveness. So the SBA on Friday, May the 15th, finally released the application for the Paycheck Protection Program loan forgiveness. So that is now out there and available. Definitely take a look at that if you haven't seen it yet to get a good understanding of some of the information that you're going to be asked to provide in order to get your loan forgiveness if you took one of these loans. So we just wanted to go over some of the important points from that. You want to view this video in combination with my other video on loan forgiveness because a lot of that information still applies. We're just going to touch on some of the key elements that were maybe missing or clarified with the loan application and the instructions that they provided during that process. I'm still hopeful that they're going to issue some more guidance because there are still some questions that need to be answered that the CPA community and others are saying we still don't have full clarity on a few items. But I am also still hopeful that this is probably sufficient for a lot of people who have a very simple forgiveness calculation. You should be able to kind of get through this pretty easily. I'm hoping. So we'll see kind of how that works out once we start actually trying to apply for some of these. So the application does need to be submitted to the lender that actually gave you the funds, or in the event that the lender sold your loan. I'm not sure who would buy these loans, but there's probably somebody out there. So in the event that they sold the loans, you can definitely go ahead and give that to the lender that actually owns your loan at that current point in time when you go to apply for forgiveness. So just kind of keep that in mind. In terms of some of the things that they were clarified, there is no cliff on the 75% rule. So that's an important one. There was definitely some people that were thinking if you didn't at least spend 75% of the loan proceeds on payroll costs, then you get no forgiveness at all, which I'm glad that they came out and clarified that. I never really believed that was going to be the case. I thought it was always going to be prorated, but they just clarified that with this application and the calculations that it is prorated. So just as an example, let's say you got a loan of $100,000, but you only spent it, when I say spent, I actually mean you had eligible payroll costs. Let me use the word eligible instead of spent. You have eligible payroll costs of $60,000 over the 8-week time period. And so all that you would be able to get forgiveness on would be $80,000 in that scenario, which is $60,000 divided by 0.75. So that's the largest amount you'd be able to get forgiven. And you would include then the $20,000 as a loan, essentially. So the extra $20,000 that you didn't get forgiven would be eligible to, it's not eligible, but it is a loan, essentially. And that you pay that back over 2 years at a 1% interest rate, okay? The instructions of the application actually were very generous on the incurred and paid terminology that's in the CARES Act. So the actual CARES Act says incurred and paid payroll costs are eligible for forgiveness. They came out and said, when I say they, the SBA, the Small Business Administration, came out and said that, well, we'll be a little generous with that and say anything that you pay during the 8-week time period and anything that you incurred but paid it by the next payroll date, we will count that. So to clarify what that means, I have an example here that will kind of go through that will explain that. So let's say, for example, that you have payroll that ends on the 15th and the last day of each month, okay? So you have 2 payroll cycles per month. And let's say you received your loan on April the 24th and you paid out your first payroll after receiving the loan on April the 30th. That full payroll counts even though some of the pay relates to work earned by employees prior to your funding date of the Paycheck Protection Program loan, okay? You then count your payroll paid out on May 15th, the full amount, May 31st, June 15th, the full amount for those 3 pay periods. And then you also get to take 4 days between June 16th and June 19th, as long as you pay it out by June 30th, which is your next payroll date. Okay, so you get to count 4 days of payroll at the end of your payroll, at the end of your 8-week period, as long as you pay it out by the next payroll date. So pretty favorable rule in terms of the paid and incurred component for the forgiveness. So that was one thing that we're happy about. Now to something that we weren't so happy about. So, and this really applies to S corporation owners and C corporation owners, okay? So due to the, basically they limited the payroll costs that you're eligible to pay yourself to the same rate of pay that you paid during 2019. So what that means is you take the amount that you paid yourself during 2019, you divide that by 52 weeks, multiply times 8 weeks, that's the maximum amount you can basically consider for forgiveness in this program. For any owner employees or basically S Corp shareholders or C corporation stockholders, that's what the maximum amount is, okay? So $60,000 for, let's say for example, you have $60,000 of pay that you paid yourself during 2019. To put that in perspective, the maximum amount you can pay yourself during the 8-week time period from the PPP funds to qualify for forgiveness is $9,231. Okay? Basically what they're saying is you can't increase your compensation to get the full forgiveness. The reason I believe they did that is to make it fair with the other entity types. So partners and sole proprietors already had that rule in place. And so I think what they were trying to do is just make it fair for all entities to use the same rationale or the same process. So that's the rule that came out that was not favorable. That said, there's no rule currently that you can't hire additional employees. I mean family members, no, I mean employees, to basically work in the business during that time period to help you out, and you pay them a reasonable wage based on the tasks they're performing. So there's really no rule in place that would stop you from doing that. So I do believe that you can still do that, and you would still be able to use those costs to qualify for the full forgiveness, hopefully. That said, who knows if they're going to come out with some rule that takes that down and changes that thought process, but hopefully they don't, and they do allow it. I mean, the whole intention is to increase the payroll out there and keep people from the unemployment line. So if you're keeping people off unemployment by paying them, which by the way, if you are using this PPP funds, you should not be also getting unemployment. Let me just tell you right now, I think that's fraud, and I think they're going to come up with some way from the state unemployment offices of asking for information on these loans and trying to verify what's going on here. So don't do both. If you're, just come off of unemployment for the 8 weeks, and then if you're still not really having good business, then go back on it after the end of the 8 weeks. So don't try to double dip, okay? Also, so for the non-payroll costs, one more thing before I get to that. There is an alternative payroll period that they came out with as well. So instead of just using the 8-week period that starts the date you receive the funds, they allowed you to use an 8-week period that starts the day of your first payroll after you receive the funds. Okay, so you can do that only for the payroll costs. You can use this. You cannot use this for the non-payroll costs, but just for the payroll costs, you can basically start the time period that on the first day of the payroll period that starts after you receive the funds. So just kind of keep that in mind. That is something that they gave you as an alternative period to use. For non-payroll costs, they're still allowed, obviously, and the non-payroll costs I'm referring to are mortgage interest, rent, rent is both on personal property and real property, by the way. They did clarify that with these rules as well. And then the utility payment. So you get to include all those as non-payroll costs. Again, those are limited to 25% of the forgiveness, but those are still includable. During the 8-week period, even if a payment relates to a previous month of services, so basically what that means is you can apply for forgiveness with the non-payroll costs for the portion of time that you're paying during the 8-week period, and also for anything that you've incurred but haven't yet paid, as long as you pay it by the next billing date, or I think what they intended to mean is payment date for that utility bill, so or interest payment or whatever it is. So you can basically do that as another alternative to do that. There is no alternative pay period for those again, so you do have to still use the regular 8-week period that starts the date that the loan was funded for the non-payroll costs, okay? They also clarified the full-time equivalent calculation to where the full-time equivalent is the number of hours paid per week divided by 40 to get you to your average, and then you round that to the nearest 0.1% to determine how much of a full-time equivalent an employee is. They also gave an exception or an expedient where you can do 0.5 for an employee for anybody who works under 40 hours a week, and then 1 for any employee that works more than 40 hours or more during the week. So they gave you a little practical expedient for that to help with that calculation if you so choose to use it. I would probably start with that and see if that would get you to the point where you get full forgiveness. And then if for some reason you're not getting a full forgiveness, then I would probably go to the more detailed calculation and see if that one's more favorable for you. The application clarifies what documents you also need to provide to the lender to qualify for forgiveness. And those are the documents that you'll want to keep in your records. So those are all still very much applicable. I'm not going to go through the details of those. I think they're pretty standard, honestly, in terms of the documents that you would expect them to ask for. So, but it does have that information in there. They say that this application should take you about 3 hours to complete. I think that depends on how many employees you have. If you have like 5 employees, I think, yeah, it could be 3 hours or less potentially. If you have, let's say, 50 or 100 employees, or some of those people have 500 or more employees, this application can take you a lot more than 3 hours to complete, because you have to do some calculations and some other stuff that are not easy to do per se. So I think they're a little understating that for some of these. So we'll see how that plays out. But I definitely recommend that you work with a CPA or attorney or some other advisor to help you with the calculations and make sure that you're fully understanding everything. Now, whether they charge you or not is another story. That's between you and them, but ultimately that's kind of the story behind the forgiveness. So that's the update for today. Hopefully that was helpful to you guys. Hopefully that provides a little bit of clarity on a few issues. Definitely take a look at the application. If you have any questions, in regards to any of this, or you have any comments or anything, obviously please leave those in the comment section. Happy to try to answer those as much as I can. And we'll go from there. So hopefully once they issue some additional guidance, we'll get some more clarity. I'll do another video to update you guys on that, and we'll go from there. All right. Hope everybody has a good day. Bye.